5 seconds to go. Start. Feeling aggrieved and dissatisfied with the impugned common judgment and order dated 6th October 2021 passed by the High Court of Jammu and Kashmir and Ladakh at Jammu in respective writ petitions preferred by the private respondents herein, original petitioners, whereby the appellants herein, original respondents, have been directed to determine the compensation of the acquired lands in accordance with the provisions of the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013, hereinafter referred to as the Act 2013. The appellants herein, original respondents, have preferred present appeals. The facts leading to the present appeals in a nutshell are as under: that the lands in question were sought to be acquired under the provisions of the State Land Acquisition Act 1990, hereinafter referred to as State Act of 1990. The notification under Section 4 of the State Act of 1990 was issued on 15th November 2016. The lands in question were sought to be acquired for the appellant's beneficiary. That thereafter, declaration under Section 6 of the State Act of 1990 was issued on 12th November 2018. The landowners, original petitioners, filed the respective petitions before the High Court challenging the proceedings initiated under the J and K Land Acquisition Act SVT 1990 with the following prayers: certiorari, so as to quash the proceedings initiated by respondents under Section 4, 6, 9 and 9A and Section 17 of J and K Land Acquisition Act SVT 1990 for the acquisition of land for relocation of petroleum depots from villages mandamus, so as to command and direct the respondents to denotify the land sought to be acquired in villages, Tehsil and District Jammu for relocation of petroleum depots. Prohibition, so as to restrain the respondents from taking the possession of land falling under various khasra numbers of aforesaid villages under Section 17 of J and K Land Acquisition Act. That during the pendency of the writ petitions before the High Court, the State Act of 1990 came to be repealed. When the aforesaid writ petitions came up for hearing before the High Court, the learned counsel appearing on behalf of the original writ petitioners submitted that the petitioners would be satisfied if, instead of quashing the land acquisition proceedings, determination of compensation is made in accordance with the provisions of Section 24 of the Act 2013. It was the case on behalf of the original writ petitioners before the High Court that, as neither the possession of the lands in question have been taken over, nor the award has been declared even under the State Act of 1990, the original writ petitioners shall be entitled to compensation of acquired land in accordance with the provisions of Section 24(1) of the Act 2013. The aforesaid prayer was opposed by the appellants on the ground that as the acquisition proceedings have been initiated under the State Act of 1990, Section 24(1) of the Act 2013 shall not be applicable at all. Stop.